proposes a deletion. The fact that there is no one to prosecute that, it's hereby dropped. There is another amendment by the chairman. Please proceed.
I propose that the clause 8 be amended as in the order paper, and basically that is to ensure collaboration between the national and the county government in the access and delivery of assisted reproductive services to all. That's already provided for in the above. Remember when we were discussing 7.
Honorable members, since the proposals by the Honorable Kaluma are appearing in so many clauses, and the fact that the Honorable Kaluma is not in the House, and that there is no one to prosecute the amendment on his behalf, and the fact that he participated in the winnowing process, I would like to drop all amendments by the Honorable Kaluma instead of calling them out in every clause. So, honorable members, now we go to clause 8. I now put the question that clause 8 be amended as proposed by the chairman.
If you allow, I may want to have a consultation with that on what you have just said of dropping all Honorable Kaluma's assessment with Honorable Millie, then we proceed. Just 2 minutes or 1.
Going forward, right? It's going forward. It's going forward. Beyond clause 8.
So that is what I want to consult about, so that as we go forward, we are now quite clear they're all dropped.
Yes,
I'll tell you my concern. If a member is not there, we are dropping. We do not know how later on he'll behave towards the whole bill, even the act when it is passed. That's why I wanted this consultation.
Who do you want to consult?
Honorable Millie.
Okay. Can we give you a minute to do that? You may proceed.
Thank you, Chair. Maybe just what Honorable Nyikali is worried about, that he wants to go on record, is that we agreed largely in the harmonization process, probably 90%, but there were about 3 clauses we didn't agree on, and which Honorable Kaluma had wanted to prosecute himself, but he's not here. Out of goodwill, because I know we are not obligated to take that into account, but out of goodwill, we agreed that we could request for recommittals of those ones. So what Honorable Nyikali is worried about is if they are dropped, can they then be subjected to recommittals?
Honorable Millie Odhiambo, are you able to identify the 3 together with the chair? And also the fact that the Honorable Kaluma has not given you any document in writing indicating that you are going to move on his behalf. I can give an opportunity to the chair when it comes to those specific amendments which you have already agreed, you can move the amendment and then move in an amended form to take care of Honorable Kaluma's amendments. Yes. Honorable Millie?
I think we're just being magnanimous, Chair. The committee and myself do not agree with Honorable Kaluma on those amendments. So he wanted to prosecute his disagreement, which we have graciously agreed to allow him to prosecute, even though we disagree with him. So if we move, it would imply that we are supporting, which we don't. The committee doesn't support, I don't support. But we wanted to be gracious enough to allow him to move his opposition. So our concern is that because we have agreed, gentlemen, we have had a gentle-lady agreement to recommit so that he can come and persuade members on those 3 items. Would it be okay, Chair, if we just moved all of them and when we came to those 3, we notify the House so that he will be allowed later to recommit?
Also, as you do that, you bear in mind that now the bill belongs to the House. It doesn't belong to the Honorable Kaluma. You may proceed, Honorable Dr. Nyika.
Chair, that is exactly why we are asking. We went through a very rigorous winnowing, actually, almost twice. And so on I have all the clauses that we didn't agree, and we said, let's prosecute those on the floor of the House. Now, if then we now proceed and say later on, my concern is much even later on, he raises issue of the process, he was aware or not there, because we know even acts that we have passed have actually been challenged on the issue of process. If they, suppose, for example, we don't finish, and tomorrow or the next week when it comes, then is available and he wants to recommit because they were dropped while he was not there, does the process allow him to recommit? Because I would like that, because in that case, we can say you even give an opportunity to the last minute, even to recommit. So you can now, not later on when we have passed the law. And Madam Chair, why I'm saying that, I know about this law, and I know that even during implementation, people may still raise issues. So I'm looking forward, and as far as Honorable Kaluma is concerned, I would like him to have maximum opportunity, be on the floor, put his case, and either win it or lose it on the floor, than just saying, I wasn't there. That's the request we are asking, in terms of process and procedure.
Yeah, honorable members, recommitting these bills will be opening these clauses to now fresh deliberation. Those particular clauses. So I am going to advise that based on Standing Order 133.10, that consideration of any part of a clause of a bill may be postponed until such later stage of the proceedings into committee on such bill as the committee may determine. So you may identify these 3 clauses so that we deal with all the other clauses and leave those particular clauses to be handled at a later time. Okay, so we proceed. Clause 8. Please use the, give him the mic, yes.
In line with what you have said, I've actually listed all those clauses where we have this, and I would like to present them to you so that when you reach that,
we need to make progress, honorable members.
8 is one of them, so we'll then save all of them. Yes. So we'll then move.
Please enumerate all of them. 8.
8, 14, 27, 30F, and 52. Actually, 18, 30, and 52.
You have added 18.
No. 14, 27, 30, and 52. No, 7 we have passed, so that is gone. I don't want to take the house back. So 8, 14, 27, 30, 52.
You said 30F.
I think there may be another part of 30, so we probably just exclude the whole of 30.
Noted. So then, honorable members, pursuant to Standing Order 133, 10, clauses 8, 14, 27, 30, and 52 are hereby postponed until such a later stage of the proceedings in committee on which the clauses will be determined. So, honorable members, we can now proceed.
Clause 9.
I propose the question that clause 9 be part of the bill. Chairman? Honorable Dr. Nyikal.
Yes, Chair. I propose that clause 9 of the bill be amended as in the order paper, and the justification is for the alignment with the proposed amendment that the assisted technology be established under Kenya Medical Practitioner Dentist Council. As I said earlier, whenever the word directorate or comes, it will be amended to read council or to be deleted as appropriate.
Thank you. Thank you. I propose the question that clause 9 be amended as proposed by the Honorable Dr. Nyikal. The Honorable Andrew Okwome, member for Karachonyo. Honorable member for Karachonyo, please use the next mic. What were you trying to do? You are trying to fix it?
Yeah, it is
You
stuck.
are trying to fix the microphone for Parliament.
Yeah, it is stuck somewhere.
Okay,
I
thank you
couldn't
very
get
much.
out of that place.
But please use that one. The one you're using now is in order.
Yeah, I can use this one. Madam Speaker, I didn't ask to be given a chance for comment. Yeah, I didn't ask for. I didn't ask to speak.
That is noted, Honorable. Honorable members, I propose the question that clause 9 be amended as proposed by the Honorable Dr. Nyikal. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 9 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 10.
I propose the question that clause 10 be part of the bill. Honorable Dr. Nyikal.
Chair, I propose that clause 10 be amended as in the order paper, and the reason is the same. It still has to do with change from directorate to council.
I propose the question that clause 10 be amended as proposed by the Honorable Nyikal. The Honorable Joshua Kimilu, member for Kaiti.
Yeah, thank you, Madam Speaker, I support.
Thank you very much, honorable members. I now put the question that clause 10 be amended as proposed by the chairman. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 10 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 11.
I propose the question that clause 11 be part of the bill. There be no amendment. I now put the question that clause 11 be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 12.
I propose the question that clause 12 be part of the bill. Honorable Chairman. Please use the next mic.
Chair, I propose that clause 12 be amended as in the order paper, and the justification is actually for we have consent and we're just adding written informed. We have informed consent and we're just adding written informed consent. So that is just for more accuracy that the consent is actually written, not verbal. Thank you, Chair.
Thank you. I propose the question that clause 12 be amended as proposed by the Honorable Dr. Nyikal. Honorable Millie Odhiambo.
Thank you, Chair. This is one of the clauses that we agreed on. And Chair, because this is an area that is currently not regulated, if you provide written informed consent, it basically means that no person shall make use of any human reproductive material for purposes of creating an embryo unless the donor of the material has given written informed consent. And this is basically to regulate that sector so that it is not misused, because it's a very delicate area. Thank you. I support.
Thank you. I propose the question that clause 12 be amended as proposed by the chairman. Will as many as have that opinion say aye? Aye. Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 12 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 13.
I propose the question that clause 13 be part of the bill. Chairman.
Chair, I propose that clause 13 be amended as in the order paper. And Chair, it is exactly the same reason. Here, in all these clauses, we need consent, informed consent. We want the informed consent to be in writing. So again, for the same reason.
I propose the question that clause 12 be amended as proposed by the chairman. Thank you. Honorable members, I'll take this again. I propose the question that clause 13 be amended as proposed by the Honorable Nyikal. Yes, Honorable Millie, member for Suba.
Again, Chair, I want to support, except that now, of course, this one, it talks to the removal of a human reproductive material from a body of a donor after their death. That cannot happen unless a person gave informed written consent, so that you don't misuse, it's sort of like organ donation, has to be with written informed consent.
I propose the question that clause 13 be amended as proposed by the chairman. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 13 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. Honorable members, as we proceed, I would like to take this opportunity to welcome our guests. Seated in the speakers gallery this morning, we have students from Elim Group of Schools, Mavoko, Machakos County. And we have students from Dongoni Glorious Academy from Kaiti constituency in Makueni County. You are welcome to the National Assembly to observe proceedings of the House. And I would like to give this opportunity to the member for Kaiti, the Honorable Joshua, so that you may invite all students. You may be seated.
Thank you, Madam Speaker. Madam Speaker, I want to take opportunity to welcome the students in the Parliament. And I want to tell them one time we were seated there and we were trying to follow what the proceeding of the Parliament, and today we are here as members of Parliament. So I want to encourage them and to tell them to focus. And one time they will be here as members of Parliament or in other field doing a good job. Thank you, Madam Speaker.
Thank you very much, Member for Kaiti. Honorable members, as we have agreed, we now skip clause 14.
Clause 15.
I propose the question that clause 15 be part of the bill. Honorable Dr. Nyikal, Chair.
I propose that the we amend clause 15 as in the order paper. And Madam Chair, this is just purely for, that is just for wording. And clause 15 initially was indicating a person shall not undertake assisted reproductive technology for purely speculative and commercial purposes. The word purely is superfluous there. It should just be for speculative and commercial purpose. So we are deleting the word purely.
I propose the question that clause 15 be amended as proposed by the chairman. Well, I see three interests. I see three people on my screen. I see the Honorable Joshua and I see the member for Karachonyo. Member for Karachonyo, you told me that you didn't have interest in speaking to the earlier clause. Do you have interest in speaking to this clause?
For further motions and bills.
Okay.
Yeah.
Yes, and in that, honorable members, I'll request that those who have interest in this particular bill, please hit the intervention button so that it is easier to identify you. Honorable members, I propose the question that clause 15 be amended as proposed by the chairman. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 15 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 16.
I propose the question that clause 16 be part of the bill. Honorable Chairman, Dr. Nyikal.
Madam Speaker, I propose that clause 16 be amended as in the order paper. The justification for this is what clause 15 is saying, that you shall not, for the purposes of reproductive technology, place into a woman an embryo other than a human embryo, a gamete other than a human. But this says a gamete embryo other than that, they consented for by the woman. It is a complex area, and we just want to make sure that whatever is used, the woman has given consent to. So that is the essence of the amendment of 16.
I propose the question that clause 16 be amended as proposed by the Honorable Dr. Nyikal. And Honorable Millie Odhiambo.
Thank you, Chair. Chair, let me also just take this opportunity to welcome the students who are here, and especially to encourage the young girls. I know the Honorable Member was saying earlier that he sat there one time and looked down, and now he's in Parliament. But when I came in and sat there many years ago, there were no women. At least now we can see women. There were, I think, 1 or 2 women. Now we see women, and we are hoping that the time they will be here, more than half the House will be women. Let the imbalance be on the men for once. But having said that, Madam Speaker, I want to support the proposed amendment by the chair. And Madam Speaker, because the area of assisted reproduction is a very new area, there's a lot of abuse that goes on. There's a case that was reported where a doctor who was an assisted reproduction technology expert, instead of using the gametes that were supplied, was using his own gametes. And it ended up that you have more than 100 siblings who didn't know and could actually end up marrying each other, brother and sister. So because of that, I agree with the chair that a gamete or embryo cannot be put inside a woman unless it's of that which is consented to by the woman. So even if it's the doctors, if you go against what the law provides, it's a crime. And I support the chair.
Thank you, Honorable Millie. Honorable members, I now propose the question that clause 16 be amended as proposed by the chairman. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 16 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 17.
I propose the question that clause 17 be part of the bill. Chairman.
Chair, I propose that clause 17 be amended as in the order paper. The justification of this is replacing the word minor with the word child, so that we are quite sure we are using the legal word. But the bigger meaning of this, Madam Chair, is that you can obtain sperm or ovum from a child. The question would be, why would you do that? The question is, this is intended where a child is as what may be a fatal illness that can later be treated, or the treatment itself is such that they may destroy the reproductive capacity of the child, like leukemias and so on. So this is done earlier so that you can preserve that and use them later. So we have to use the correct word as in law.
Thank you. No, wait. First of all, I want to propose the question. I propose the question that clause 17 be amended as proposed by the Honorable Dr. Nyekal. Honorable Millie Odhiambo.
I just wanted clarification. Chair, I've heard the chair of the committee saying that is only amending the word child. But what I have here indicates that you're doing much more than that. I don't know if I'm the one who has it wrong. Because I think the proposed amendment that I got from the committee report is a person shall not obtain a sperm or ovum from a child or use any sperm or ovum obtained from a child except for medical reasons and future human procreation and with the informed consent of the minor's parents or legal guardian. If that is the case, then I'd support. If that is not the case, then could I please move a further amendment? Because that's what we agreed with the Committee on Harmonization, and it's to protect a child, especially children who may be going, as he has said, through medical conditions like leukemia or other cancers that may affect their future abilities to have children, and therefore you need to freeze their eggs or sperms for future procreation. So maybe if the
Chairman,
chair can
please
clarify.
make the clarification and be brief. Honorable members, remember we debated on this bill for a very long time, so we can just make sure that we are on point. Are you amending the word child alone, or it is beyond that word?
It is beyond.
As it has been explained by the Honorable Millie Odhiambo.
It is beyond, and in the context that you said, that's why I earlier said you may harvest the ovum or sperm from a child for later use by the same child. If they are sick and the cost of treatment will reduce them infertile, then we can save this for later on when they have recovered, and now they can be used by the same child with the child's consent or the guardian's consent. We concur completely.
And listening to the two of you, I think that you agree. So, honorable members, I now put the question that clause 17 be amended as proposed by the Honorable Dr. Nyekal. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 17 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 18.
I propose the question that clause 18 be part of the bill. Honorable Dr. Nyekal.
I have an amendment on clause 18, and that the clause 18 of the bill be amended as in the order paper. This is again to protect the use of embryos, so that the embryos that can be used are only human embryos consented to, because in this technical area, it is possible when you are using embryos, even to use embryos other than human. So this is protective, so that we only use a human embryo, and that is the gist of the amendment.
Thank you. Honorable members, I now propose the question that clause 18 be amended as proposed by the chairman. Honorable Millie Odhiambo.
Thank you, Chair. I know it's in my interest and in the interest of the House that we move very quickly. But because there's also been a bit of misinformation about this bill, it's good to put some things on record. And part of what the Chair is proposing in this amendment is that there shall be no form of human cloning. And I support, amongst other things, and the using or mixing human organs with animal. So there is no form of human cloning.
Thank you. Honorable members, I now put the question that clause 18 be amended as proposed by the Honorable Dr. Nyikal. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it. I now put the question that clause 18 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it.
Clause 19.
I propose the question that clause 19 be part of the bill. Honorable Dr. Nyikal.
I propose, Chair, that clause 19 be amended as in the order paper. And the justification actually are two. One, for the use of the word consent. And that is, as I explained earlier, that it must be written consent. And two, we also want to remove the words placing sperm and eggs or embryo in a woman. We want to be more specific and say in the womb. If you're saying in a woman, it is general. We don't know where it is being placed. So this is specifically in the womb. But also for the reason that you can't place sperms and eggs at the same time, because sperm and eggs or and embryo at the same time. It must be or, because once you have an embryo, definitely you don't need a sperm or you don't need an egg, because the embryo has taken care of both.
Thank you. Honorable members, I propose the question that clause 19 be amended as proposed by the chair. There be no interest. I now put the question that clause 19 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as have a contrary opinion say nay? There is have it. I now put the question that clause 19 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it.
Clause 20.
I propose the question that clause 20 be part of the bill. Honorable Dr. Nyikal.
This is deleting, just changing the marginal note and replacing the word with posthumous reproduction. And as we probably as we had indicated earlier, it is possible that when people are sick and they are likely to die, you can actually take their sperms or eggs and use them later if they do die. So that is called posthumous reproduction. Then these are frozen. Therefore, we want the words to be quite clear, and posthuman reproduction is the correct word, not what is in the note, the side note now.
Can I call first before we do point of order? Actually, Chairman, you still have more to move because we called the whole clause 20. Would you like to prosecute all amendments now? Maybe that is the same matter that the Honorable Millie Odhiambo wants to raise. You have only talked about posthumous production.
Yeah, the posthumous.
You have B, C, D.
What then? It is still posthumous reproduction.
You can give us justification for each one of them.
Okay.
Make it brief.
For the side word, we have said the renumbering, obviously, then that is remembering. Deleting is because we have done that. But the most important one there is D. I think that's what Honorable Millie may be concerned about. When you do this posthumous reproduction, then the question comes that if you use an embryo, the ovum of a woman or an embryo, and how you place this must be in consent with what the woman wanted in terms of parentage. You cannot take that and put in another woman, and then when you now, the baby is born, you attribute the parentage to the woman who has died while she did not give consent for that. I think that is the issue that Honorable Millie is concerned about.
Thank you. Now, from our desk, you have covered all amendments. I'll now propose. Honorable members, I propose the question that clause 20 be amended as proposed by the chairman. Honorable Millie Odhiambo.
Thank you, Chair. In fact, in light with what the Honorable Chair has said, I wanted to propose a further amendment to delete the word "and" between subclause 2, which provides where the ovum of a woman or an embryo, the creation of which resulted from the ovum of that woman, was used after the death of that woman shall not be treated as the mother of the child born out of the ovum or the embryo unless the father was, the father was married to the woman at the time of the death of the woman, and then there is the word "and." The woman had given informed consent in writing. When you have the word "and," the implication is that, let's say I'm married now, and we decide to go through assisted reproduction technology with my husband. And unfortunately, my husband dies. No, actually, it's where the woman dies. Where the woman dies, then the child shall not be considered as mine unless I wrote or I gave a written consent to my husband. It doesn't make sense. Where people are married, there is no reason for written consent unless it's posthumous. Not posthumous. Where they are married, even posthumous does not apply. Let me give an example. Assuming you are married, you understand me? Yeah. If you are married right now, even if you don't have a child under assisted reproduction, and your wife dies, that is your child. You don't need to sign anywhere. That's your child. But if you say "and," the word "and" gives a totally different meaning. So I'm proposing that we delete the word "and." The father was married to the woman at the time of the death of the woman.
I would like to give a chance to the chairman.
We concur. Basically, if you put the word "and," then the two conditions in A and B must be met together. Whereas if you delete "and," then A stands on its own. The father was married to the woman at the time of death of the woman. So there's no need for consent there. And then B, the woman had given consent. This may be in the case where a woman was actually probably not married and she had agreed to this. So there you would have needed her consent. Yeah. So the two conditions in A and B need not be tied. Maybe we can use the word "or," but for me, whether you use "or" and you delete it, I think it has the same thing.
Yes, Honorable Ole Sunkuli.
I am of the opinion, Madam Chair, that if you really don't want those two conditions, then just drop the whole idea, that particular amendment. No, I think that you don't, because informed consent is essential for all these things. So why would you need that to say that? Pardon? So if they are married, then why do you have to legislate? Why don't you just leave it?
In fact,
It's so sensitive, but I would like to hear the final word from the chair.
why you need to is you may be dealing with a married woman. So if you're dealing with a married woman, then A applies. So nobody can raise an issue.
Honorable Ole Sunkuli,
If they're married,
I was thinking that you'll stay around the Honorable Dr. Nyikal so that you can be more
we've
useful to the
discussed
House.
this even with him before.
So that you can be more useful to the House. Or
So B,
okay.
so B, it will apply actually when the woman is not married. Therefore, you need a written consent. But where they are married, you don't need. But still, people can raise an issue because what you are dealing with here, the woman gave her ovum. It was used when alive, but then she died. This ovum was then put in another woman later on. Now, if that woman that is married to later on is now married to the man, then there is absolutely no issue because there is a link between the baby and the man. Now, if they is not married, then the two people or the person involved with the woman, if the other woman is married or not, now there's no link whatsoever. So therefore, you needed to have given the consent in writing earlier, which means that it is in consultation. You can't just say, okay, there are some women, there's an ovum bank, and this ovum bank, there are women who have died, so somebody then says, I can take that ovum and use it, and now I can get pregnant. Now, when I get pregnant, then at the end of it, I turn around and say, no, that ovum belonged to that woman, so that this child now belongs to that woman who has died. Honorable Sunkuli, what we are saying is somebody who was mischievous, they've used the ovum of the dead woman seeking to have the child. Now, when the child is born, they now want to abandon the child and say the child actually belongs to the dead woman. Now, if there was no consent from the woman, then that is not true. She must take responsibility for this child, because otherwise this child will remain parentless, nobody to link to it. That is the essence of splitting the two.
Honorable Mili, I would like to ask you to approach the table as we give a chance to the...
Madam Chair, then in that case, if we want those two conditions to exist, then why don't you delete why don't you delete "and" and replace with "or"?
Yeah, as I said, I'm perfectly okay with that.
Okay.
Yeah.
So I'm saying that.
Let's hear the Honorable Ole Sunguli.
No, I'm just saying then we delete "and" and replace with "or."
Yes.
So that there are
Noted.
two conditions.
Noted. So in that case, thank you very much, Honorable Ole Sunguli. I'll give a chance to the Honorable Mili to move a further amendment to the amendments by the chairman.
Thank you, Chair. Chair, I wish to move a further amendment to the amendment by the Chair in clause 20, subclause 2, A and B, by deleting the word "and" which comes after subclause 2A and replacing with the word "or." Thank you.
I propose the question that the chair's amendment be further amended as proposed by the Honorable Mili Odhiambo. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 20 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 21.
I propose the question that clause 21 be part of the bill, Chairman.
Chair, I propose that clause 21 be amended as in the order paper, and in A, again, as I said earlier, it's just the word directorate being replaced by council because of the earlier amendment, and in B, the justification is that the children born out of assisted reproductive technology also have a right or parental care and protection as guarantees under the Constitution without how they came into this world should not be an issue. That is the essence of the second part of that amendment.
Thank you. Thank you, honorable members. I propose the question that clause 21 be amended as proposed by the chairman. Honorable Mili, I see you have interest in this.
Yes, Chair, I support the chairman's amendment, which gives better protection to children born of assisted reproduction. I've just noticed, Chair, and you'll guide me on this, that I had wanted to do a further or amendment to the title, which is Part 4, Rights of Parents, Donors, and Children. But I noticed the chair didn't have an amendment there, but I just noticed that we are focusing on, we've been through this a lot, but every day something new comes up. We have not focused a lot on the rights of the surrogates. So I just wanted to put something on surrogates, but that would require that we change the title. Wait, at this point?
Like the title be the title.
Okay,
We are not able to deal with the title at this moment.
thank you,
We cannot deal with it at this moment.
thank you.
So since you supported. Honorable members, I now put the question that clause 21 be amended as proposed by the chairman. Will as many as have that opinion say aye?
Aye.
Will as many as have a contrary opinion say nay? The ayes have it. I now put the question that clause 21 as amended be part of the bill. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Clause 22.
I propose the question that clause 22 be part of the bill. Chairman.
Chair, I propose that clause 22 be amended as in the order paper. And the essence of this is that basically all the services that are given are actually on medical grounds. But let me look at it a little more. Yes. The national county government put in place.
Yes, sir, Chair.
Basically, this is because this was actually seeking that asking the national government to put in place services that is already taken care of earlier in another another clause. So we don't need it at this point.
So you are deleting.
You are deleting.
I propose the question that clause 22 be deleted as proposed by the chair. I now put the question. Millie, do you have interest in this? Yes, you may proceed to prosecute.
Yes, Chair, this is one of the areas I did not agree with the committee. Because the committee said that once you provide rights for everyone, that's sufficient. But because we know that intersex persons have very unique needs, I thought it was necessary that we mention them very specifically, because clause 22 just provides that the national and county government shall put in place measures to ensure that all intersex persons have access to assisted reproductive technology services. For me, really, when you have a special category that is not given sufficient focus or attention, then you need to give them attention. So on this one, I wish to oppose the proposed amendment by the committee.
Well, in that case, the House decides. Yes, Honorable Esunkuli.
It is here.
If you look at, for instance, clause 14, that a person qualifies to undertake assisted reproductive technology where it is certified by a medical doctor that the person requires assisted reproductive technology on medical or health ground. So I think that's why the opposition to that particular clause 21, which was reading, 22, which is reading.
We are on 22.
Yeah, no, I'm trying to show
The county government.
the reason why.
You want to be very specific.
Exactly. Maybe I see that to the chairman.
So, Chair, can I?
The point of contention is the chair is proposing a deletion.
Yes.
And the Honorable Millie Odhiambo is suggesting that that deletion should not happen, and she has given her own justification. I think it's a matter of asking whether intersex.
Chair, can I put more explanation?
The intersex also have human rights, just as earlier we had the thought that children born of surrogacy are also automatically provided with the human rights. Please explain, and then for the purpose of progress, I'll put the question.
The issue is earlier in 14,
Yeah.
we have provided that.
Please use the next mic. This is working.
Which is working, both, can you hear me?
You're not being heard very well.
Okay. Chair, the issue here is, and in 14, we provided that those who need it, people who need the services, will get it on medical grounds. So as long as it is medically required, they'll get it. What 22 is seeking to do, 22 seeks to say that we say this specifically for intersex people. And they argue how the committee saw it. In that case, you will then start having people with, you can also then say people with disability, or even more specifically, people who are deaf, or specifically people who have medical problems. So other than this, so that if you now start affirmative action for one group, are you going to have affirmative action for all groups? So that is the you say that if 14 suffices, now you can't discriminate against people with intersex because you have said everybody deserves it. So why then are we now repeating that people with intersex should also get it? So long as you have said everybody should get it. That was the point.
Yes. Honorable Millie.
Thank you, Chair. Chair, what I wanted, the reason I didn't agree with the committee on this is that you cannot compare an intersex person with a deaf person when we are talking about reproductive issues. Because an intersex person is a person who presents with the two organs, male and female. And that therefore means that will necessarily face serious challenges of a reproductive nature, especially if they're looking for assisted reproduction. That cannot compare with a person who is deaf or blind, for instance. They will face challenges, but not as much as a person with intersex. And Chair, that is why, for instance, when you're talking about leadership, we know that women will face challenges of leadership. But when it comes to issues of reproduction, I think there's no category that will suffer as much as intersex persons. And that is why I thought it's necessary that we provide very specifically for intersex persons so that when they go to hospitals, they are treated specially. Because I'm sure, Chair, you have come across people who don't know whether they are Millie or they are Mark because of that. And when they go to hospitals, they are treated the same way. When they go to banks, police are called on them, and it's not their fault that they have two organs, which is both male and female.
Honorable Millie, I think I only have an opportunity to ask the House to make a decision. I now propose the question that clause 22 be deleted as proposed by the Honorable Dr. Nikal. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 23.
That was a deletion. Yeah. Yes, we may proceed.
Clause 23.
I propose the question that clause 23 be part of the bill. Chairman.
We propose that clause 23 be amended as in the order paper. And the reason for this is to make provision for obtaining prior consent in the event of unforeseeable circumstances, such as death or divorce, so that once the agreement has agreed on the use of the gametes, then we'll need some consent on how these gametes are later on actually used. And that is the essence, so that you don't have gametes that are produced and then either they are abandoned or they are used in ways that the people who produced them did not intend them to be.
Honorable members, I propose the question that clause 23 be amended as proposed by the chairman. I only see the Honorable Millie Odhiambo interested in this.
Thank you. Chair, I wish to support that provision by the committee because they are giving a very specific, or rather they are giving clarity in relation to what should be done with the gametes subsequently. And I want to say, because Madam Speaker, I'm not, this is not really my area. And the committee actually gave very good technical expertise. So this is one of those areas I'm really appreciative of what the committee did.
Thank you, honorable members. I put the question that clause 23 be amended as proposed by the Honorable Dr. Nikal. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it. I now put the question that clause 23 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it.
Clause 24.
I propose the question that clause 24 be part of the bill and there be no amendment. I now put the question that clause 24 be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it.
Clause 25.
I propose the question that clause 25 be part of the bill. Chairman.
Chair, we propose that clause 25 be amended as in the order paper, which is a deletion, and it has listed conditions. But the basic issue here is all those conditions are placing marriage as the main qualification for having assisted reproductive technology services. And the committee's position is that marriage should not be. So if you want assisted reproductive technology, if you are married or not married, you should get the services. Basically, that is the justification for that deletion.
I propose the question that clause 25 be amended as proposed by the chairman. I do not see any interest in this, so I put the question that clause 25. I propose the question that clause 25 be deleted as proposed by the chair. No interest, so I put the question that clause 25 be deleted as proposed by the chair. Will as many as have that opinion say aye? Will as many as have a contrary opinion say nay? There is have it.
Clause 26.
I propose the question that clause 26 be part of the bill, Chairman.
Chair, propose that clause 26 be amended as in the order paper, and the justification in A is indicating how people or children that come from assisted reproductive technology process should be treated as others, and the word that was being used as different from children that arise from sexual intercourse. And we felt that that's rather crude, and we used the word natural conception, which means the same thing, but I think is more civil. Then in B, this is already provided for, and in C, to align with the proposed amendment that the bill shall only apply to Kenyan citizens, and hence the question of citizen of a child born as a result of assisted reproduction does not arise. This bill actually, as is now, is basically the services will be available to Kenyans, so that when children that come out of this process, there is no question they are Kenyans. I think that is what we are actually indicating there.
Thank you. I propose the question that clause 26 be amended as proposed by the chairman. Honorable Millie.
I support, save that I want to remind the chair that we have not yet moved the amendment in relation to this bill being preserved for Kenyans. So I notice it is coming much earlier, so we might actually have to do a recommittal to provide for Kenyans. Otherwise, I support.
I propose the question that clause 26 be amended as proposed by the chairman. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it. I now put the question that clause 26 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? There is have it.
Clause 28.
Skip 27 as agreed earlier. I propose the question that clause 28 be part of the bill. Chairman.
For Kaluma, yes.
Yes, 27 is among the clauses which we agreed that will be handled at a later date, as it will be scheduled by the House Business Committee.
Let me see why we did D. Yeah, I know. We propose that clause 28 be amended as in the order paper. In A, we replacing the word parties to a marriage and replacing the word intended parents. Again, the reason there is basic. If you want party to a marriage, then you are limiting it to only married people. If you say intended parents, then they could be a couple but not married. I hope the word couple does not imply legal marriage. Then in B, there is need for a contact person, and therefore, if you have surrogacy, then the person involved should indicate who the next of kin is. So that is made clear in that clause. Now, justification to cross-reference to the name of the child born through, basically here, the issue is if the person who provided the ovum, if the ovum and the egg that is used in surrogacy are such that those people who produce them are not linked to the surrogate parents, then when the naming of the parentage of the child comes, it should not be automatic that the people who intended to have the child will have it. They will need a court order. And the reason for that, if the sperm or the ovum is with somebody who is related to the child later on, then obviously the child has a genetic link, and therefore the committee's position is that it is safer. If on the other hand they are not, then the committee is of the view that these are people who can...
Dr. Nyikal, I know you are a medical doctor, and you want to make it simple, I mean, for all of us to understand. No matter how much you explain, we may not understand. So when you go to the trust that the bill has been debated, the fact that the committee has done a lot of work on it, and now we are in the committee of the whole house, if you can just make it brief so that we can make progress. Out of order, Honorable Millie Odhiambo.
Thank you, Chair. I'm actually just trying to make your life a little more difficult based on what you've just said. If you notice, the proposed amendments in clause 28 are quite a number. And I agree with all of them except one. So when we move all of them, if we move all of them together, it will deny me the opportunity to oppose the one that I wanted to oppose. So I would wish to request that in relation to this one, that we move them by sub-clauses. Because there are sub-clauses I agree with, But there's a subclause I don't agree with.
That is okay, Honorable Mili. So you'll give the House an opportunity so that we are able to propose the question for the purpose of debate. Then when we get to that particular, you can identify it and see whether the House will agree with you. So I would like to give a chance to the Honorable Chair to finalize. Then I put the question, then we can look for how to assist the Honorable Mili Odhiambo. So if you can finalize, Honorable Dr. Nikal.
I think the only one that was coming, another justification, that the persons entering into surrogacy agreement shall only receive benefits as a consequence of surrogacy and not process of surrogacy. Now, there what was the deletion was intended, there's an issue of whether people will go into surrogacy for commercial reasons. And therefore, in our view, that should not be encouraged. But if, because of surrogacy, they do need some material support, some financial support because of the process, then that should be allowed. I think that is what the last justification there has. I think that is where we ended. And this is talking about, this is actually referring all to the conditions of the surrogacy. Now, I think there's the last one, which is to protect the fetus as the intended parents do not have control over surrogate actions, which means once you have gotten into surrogacy and conception has occurred, you see in 8, into it, we say surrogacy agreement may indicate the terms of the agreement, including terms prohibiting the surrogate mother from partaking of alcohol, smoking, using prescribed drugs. And so it means they go into surrogacy, but now you are putting conditions to them because you need that to protect the child who is inside. So that is what means. So then I would hear what the particular issue, Honorable Milia's issue, then we can have discussion over it.
That is okay. Honorable members, I propose the question that clause 28 be amended as proposed by the Chair Health. Honorable Mili Odhiambo.
Thank you, Chair. Chair, I wish to support the proposed amendment by the committee chair. And upon reflection, actually, where I wanted to oppose, I've seen the wording is wording I could live with, because my concern was in relation to something that when we were debating this in the last parliament, Honorable Joyce Lay indicated that when she